All right. Good morning, everybody, and welcome to our seminar this morning. Leanne Hitchman and I are presenting a seminar planning for those with special needs and care concerns, steps to take and mistakes to avoid. So let's get into it. Um, First of all, thank you for being here. We understand that there's nothing more important than your loved one's care and well-being. My team and I and the Hitchman fiduciaries, Leanne and her team, have years and years of experience of working with many families navigating these waters just like yours. And we know and understand how important this topic is for each of you. You're all here for your unique reasons. We know you understand the challenge and how hard it can be sometimes being the primary caregiver. And when you get to navigating the rules and regulations and technicalities, sometimes when you're walking through the mire of government benefits, it seems like there isn't a friend anywhere. And we get it. And that's one of the reasons that we're advocates. We're here to help you and help you get through all these things. But at a base level, we appreciate you taking time out of your busy schedules to join us today to learn a little bit more about how we could be of assistance and some of the options that you have available to you. So with that being said, let me start with an introduction of who I am. We'll get to Leanne in just a minute. I am Scott Schomer. I'm an attorney licensed continually in the state of California since 1990. I'm a graduate. I obtained my Juris Doctorate degree from Boston University in Boston, Massachusetts. As I indicated, attorney licensed since 1990. I am an attorney that is a certified specialist in the area of estate planning, trust, and probate law. In addition, I serve as an adjunct professor of law at Loyola Law School, where I happen to teach these very topics, trusts and wills, to the next generation of lawyers coming up. I am the founder of the Schomer Law Group. I have been regularly recognized, I think 15 years running, maybe 16 years, as a California super lawyer. That's an award bestowed on my colleagues by vote, as well as a 5-star wealth manager. And I hold the title of being a lifetime member of the Multi-Million Dollars Advocates Forum. That means I've taken matters to trial and won judgments in excess of several $1,000,000. And I'm one of less than 1% of attorneys nationwide that can make such a claim. So I'm honored to be able to have that distinction. So that's me, but the Schomer Law Group is not just about me. I've been very blessed to be able to assemble a team around me. So let's quickly meet the team. That team includes some folks one folk that you might have been interacting with, and that's Caesar Gill, who's our operations director and leading estate planning paralegal. In addition, I have 2 associate attorneys, Jade Quintero and Julia Unger, both who are broadly fluent in a number of the issues that we'll cover today. Carmen Reynoso is our newest addition to the team. She is our client services manager. In addition, we have 2 very experienced paralegals. Nancy Berg has close to 30 years of experience and half of a law degree, more than half of a law degree, actually. And Danielle Prebix been doing this for decades as well. They both help us with our probate and trust administration and accountings, which are particularly important in the special needs area. Javari Hamilton's our younger paralegal. He's coming along fabulously and helps many of our clients. And then I am blessed. Colleen, believe it or not, is not my daughter, but my wife, and she is our chief financial officer. And I think we've assembled one of the best teams in California. And it's one of the reasons why about a dozen years ago, we were invited to join an organization called the American Academy of Estate Planning Attorneys. I think the American Academy is the best organization in the country. We're one of 250 member firms, just a few here in this area in Southern California. And it's an organization where we hold ourselves to a higher standard. We, on an annual basis, do triple the amount of continuing legal education all the other lawyers are required to do. And it's one of the reasons why a few years back, Money Magazine recommended that if you're looking for an estate planning attorney, look for a member of the American Academy, as did Susie Orman in her book, 9 Steps to Financial Freedom. But you don't have to take the word of the experts either. We do invite you to check us out online. We publish a regular newsletter. The most recent edition had sort of a running history of my pets, because pets are also very important to people. Many are creating pet trusts these days. But we have all kinds of articles and reports you can download. You can give us your email address and we'll send you regular updates. We have a robust Facebook page, Twitter, YouTube, and we have a blog page on our website with more than 1,000 posts. And one of the things that I'm most proud of is I get calls on a regular basis from attorneys around the country, and they find us by all the good material that we've published on the web, because at our core, we are huge believers in doing what we're doing here today, which is educating. And in that regard, we are all stronger and better together. And that's one of the reasons why I'm very blessed and honored to have with me nobody else other than the leading fiduciary, Miss Leanne Hitchman. So, Leanne, I'll turn the table over to you and let you introduce yourself and tell us about your team.
Thanks, Scott. Yeah. So I'm something called a California Licensed Professional Fiduciary, which means that in the state of California, unlike some other states in the country, we actually license professional fiduciaries. And I'm not a trust company. I'm actually an individual with a team, with a firm that consists of licensed professional fiduciaries. And I think that's really important because that means that there's somebody monitoring me. It means that I have to pass an exam. I have to have continuing education units. I can specialize in certain things. One of my choices of specialties is in the special needs discretionary trust arena. As to myself, education-wise, yeah, I have a undergrad degree in mathematics. I'm very popular with high school students trying to solve math problems, but that's not what I do for a living. I went to USC and earned my MBA. And I should add that myself and actually just about everybody in my firm, we are local Southern Californians. We were very blessed and fortunate to have been born here, raised here, gone to school here, including all the way through graduate school. So we're a little bit unusual in that sense. I think sometimes that gives us a really nice understanding of the grassroots of Southern California and where the families that we speak with, where they come from, many of them, particularly those that are multi-generational. And certainly within the area of any kind of special needs, so many of the families want to stay in California because the benefits tend to be better in this state than in other states. I'm also a certified care manager. And so that's not an actual license, it's a certification. And the reason why I have that is because I grew a little bit frustrated because there aren't that many care managers out there that understand this particular area. There are care managers that specialize in geriatrics, and we do some of that. But what we really wanted was to get better at servicing our beneficiaries that have various medical/care issues. So I myself am certified. I also have a full-time employee that's a nurse who is specifically on staff to address issues related to trust administration where it intersects with medical care. And in my particular area of special needs and the one that we're talking about today, that happens somewhat frequently, and we need to be able to know what to do. I'm the founder of my firm. I started about 20 years ago. We're a 10-person professional fiduciary firm, 6 licensed fiduciaries, a nurse on staff, and then other staff members. I am super fortunate to have long-term employees. And the reason why I think that's a benefit to everybody is they get to know the people that we work with And this is a very unique subject matter. It's not something that you're going to go study in school or even pick up a book necessarily. So having long-term experienced individuals in the firm, I think, is a real benefit to our clients. The other thing that we do have too is we tend to have a younger team, and that's by design on purpose. Because when you're looking at this kind of work, many of these trusts are going to last many, decades of years. And I'm not necessarily going to be the guy that's here 30 years from now. I can guarantee you I won't be working 30 years from now. So it's exceptionally important to have licensed fiduciaries in the firm that understand this kind of work and that will also be here as part of our succession plan. So we're extremely proud of our succession plan. And then I write a lot. If you want to go look at my blog, some of my articles that are on our website, hitchmanfiduciaries.com. I try to write on topics that are germane to families, particularly when it comes to some of the changes that are going on, or just some of the things that I see on a daily basis when I talk to people that I think need to be considered. For example, my most recent posting was about siblings of the children that have some sort of special needs trust. I think sometimes we forget about the siblings a little bit, and we need to think about them because when the parents are gone, or the grandparents are gone, a lot of times it's the siblings that step up. So try to make them topical. Next slide, Scott. That's me. So our goals today. Now, I'm going to digress from the slide just for a second. I want everybody here by the end of this presentation, I'm going to be blunt. I want you to be scared that if you don't have a plan, you potentially are leaving your child at great risk. And I've got lots of stories that I can share of great risk stories. And secondly, I want to motivate you because it is really easy to procrastinate and not do anything. And speaking for myself, I did that for quite a while. I'm really very lucky to have some attorneys in my lives that I work with that know me personally. And one of them literally put an appointment on my calendar and made my husband and I, Scott's laughing, made my husband and I redo our estate plan. And I can tell you from the bottom of my heart, the reason why I wasn't doing it, why I was procrastinating, was because I did not have the perfect solution. Because I, like many of you, have a child who struggles. She doesn't have a formal diagnosis and is not receiving Social Security, but she is not working and she really struggles in its mental health. And so it is really tough to know what to do. So when I talk, please know that I'm coming from my own heart. And so I want you to not be like me. The cobbler's children don't have shoes, but now they do have shoes. Put something together. The reality is no one can replace you. No one's going to make the decisions like you're making. But to do nothing is a guarantee of failure, absolute guarantee of failure. So by the end of this hour, I'm hoping that you literally call somebody, get an appointment on schedule, and start working and accept that it may not be perfect, but it's better than doing nothing. So the things we want to do is we want to see you create a form of a life care plan. What's going to happen when I'm gone? To understand what options are available to enhance your loved one's benefits, because sometimes there's benefits being left at the table. To avoid common and costly mistakes. That's probably the thing I see a lot. I get called into situations where something wasn't done or the wrong thing was done, and then we have a mess. And the biggest thing is to avoid being unprepared. Unprepared can literally leave somebody homeless. And so, like I said, I'm going to be very blunt and focus on scaring people a little bit to get you to do something. So today we're going to talk about your family's goals and the challenges that you have. We'll talk a little bit about government benefits. It isn't meant to be a hugely detailed uh, deep dive into it. You can find some extra articles on my website. We'll talk about guardianships, which are appropriate in some cases, and I should say guardianships/conservatorships. My favorite topic is able accounts. Love them, love them. Special needs trusts, and we've got a really nice slide that compares and contrasts and shows them in conjunction, and then of course answer as many of your questions as we can. So the challenges that families face. I'd like to think, in fact, I know it's true, that we have made progress. And certainly a good example is the Americans with Disabilities Act that was passed in 1990. However, the reality is still that individuals with disabilities can face discrimination, unequal access to employment, to housing, to medical care, and to insurance coverage. And I'll put in my own little plug here because it's near and dear to my heart, is the mental health things. Mental health just seems to be the stepchild of everything and is a dirty word. And so we definitely see some level of discrimination. And so those are the challenges that many families face. All sorts of different disabilities out there. A lot of times we think of physical or mobility related disabilities, and the slide is a good example of somebody in a wheelchair. The second one I think we think a lot about is the ID community, the intellectual disability community that faces cognitive, developmental, or intellectual disabilities. So we think of autism, we think of Down syndrome, we think of other types of disabilities that result in cognitive issues. Um, I really love the fact that this slide includes sensory disabilities because that's an often looked one. So that sensory it falls into just a myriad of categories. You see it sometimes evidenced as ADD or ADHD. You may see blindness or deafness there on the sensory disability, but you may also see things that are more on the autistic spectrum too. So there's a huge range there. Mental illness, frequently and not appearing until late teenage, early 20 years, in their early 20s. And so somebody is, parents are not necessarily at the time it happens equipped, may have some challenges finding even the diagnosis. You may see dual diagnosis with substance abuse. And the last one is acquired disabilities. So that could be an accident or something has happened that has caused a disability to trigger. This statistic blows me away. 53 million of us provide care to an adult or child. So that's huge, huge. I really believe there's a whole lot of people walking around not talking about it. And they're just accepting the fact that they've got a child that they know has a deficit and they're trying to plug the holes. 14 million care for a child with special needs under the age of 18. In my opinion, it's only been in the last 5 to 10 years that we really see um, is being talked about, obviously the school district. But I meet on a regular basis parents that are in their 70s, 80s, even 90s, who literally were told that their child's disability was their fault. And what did they do? They've hid it and they took care of it themselves rather than reach out, find help, find support systems, find benefits for them. They felt that it was their problem. So at least we've got a better world today, but just realize that there's a whole lot of individuals out there that didn't get the benefit that what our children get today in the school systems. And the last one is scary. 67% of families have no estate plan. And Scott, how many would you say 67% have no, or what percentage have no estate plan or have an estate plan that's 20 years old? Right.
I would say we're probably looking at upwards of 80 to 90%. Yeah.
Yeah. So again, my message to you is to scare you to a certain extent, to get you a call to action to do something about it. And just because you did something 20 years ago, it may not, in fact, I can almost guarantee you it isn't sufficient for today. Better than nothing, but not sufficient.
Leanne, just a quick observation before we go to the next slide. Your issue about sort of our self-blaming with the older generation, it's good to sort of take a perspective back and recognize how far we have come and how far we still have to go. But the one that
Yeah.
comes to mind is the refrigerator mom theory.
Exactly. That's exactly what I think of. Yeah.
If you don't, if you're not familiar with it, in the early days of autism, the medical profession was struggling to understand it, to figure out how to deal with it. And some doctor came up with a theory that the mothers were cold and that was the reason why. And uh, incredibly atrocious and harmful. And, many people labored under those types of delusions for a long, long time. And so we are getting greater awareness. We are improving the care, and that's something really to celebrate. And I really appreciate, Leanne, not only you having personal experience with some of these issues, but the fact that you've been helping so many families and understand the history and the perspective of it. Um, Really, really powerful stuff. So,
Mm. Let's see. Is that you or me, Scott? I don't know the number of the slides.
more for you.
I'm still on. Okay. So, what are our goals? We want a quality of life for our child, for our loved one. We want them to be happy, right? God, we forget about that part of it, and we want to make sure that they're cared for, whatever that level of care is that they need. So, quality of life, happiness, and care are the ultimate goals that I believe every family has for their child that needs some extra help. So, I like to look at things from a worst case scenario. Um, these are the questions you want to ask yourself. Who's going to take care and advocate for your child? Is there anybody? And here I want to highly encourage you to take a really hard look at what is typically called a circle of support. Um, it is really easy to become isolated, particularly for our elderly people that were accused of being refrigerator mom. This is their fault and so on. There's a tendency to withdraw. And also, frankly, just taking care of a child that has this extra stuff is not easy. And so, again, there's a tendency to isolate. As soon as we isolate, we tend to lose our advocates that are going to be out there. And advocates aren't just your own age as a parent. You've got to be looking at who does my child know that's younger than me? Who's going to be around? And that could be friends, neighbors, siblings, extended family. But please take a look at it. Um, Almost every meeting I have with a family, I ask this question, and I'm not very popular with some of the people because nobody wants to face it. But if you're isolating, you need to rethink how you're doing things. I'm not here to tell you how to do it because everybody has a different path. It could be church, it could be neighborhood, it could be volunteering yourself, it could be, being more involved in whatever it is your adult child is doing. But you got to figure out how to get connected. Who will ensure they keep their benefits? Um, Hopefully, you've got a good trustee that's looking at that, but that's a complicated one because in many cases, if the person is not conserved or under a guardianship, the others don't have a right to exactly manage those benefits, so they have to do it more surreptitiously or be a conduit to encourage to get the right benefits. So who can you identify? Maybe it's the trustee. I hope it's the trustee. Who will they ensure that they have every opportunity to lead a full and joyful life? And that's on all of us to do. And that goes back to that circle of support too. It is everybody's responsibility to contribute in some way to that full life.
Thank you, Leanne. Very helpful, very poignant. Um, we've talked sort of about the 10,000-foot goals, the broad picture. Leanne and I are both educators, and so we both know the power of good storytelling and or personal examples, or as a guy that didn't have the blessing of growing up in Southern California, but in the Midwest, one of the things we like to say in the Midwest is let's put some meat on the bones, right? I think you've heard that term. So we put together stories of three different families with three different needs. Of course, because our clients' privacy is paramount, these are not actual clients, but they're very similar to many of the cases that we've worked on, that we've helped people with. So let's get into it. So our first family up is the Jacksons. So the Jacksons have a daughter, Claire. She's an outgoing 10-year-old who was born with spinal bifida. Despite her physical challenges, she does well in school. She loves to paint, enjoys several adaptive sports year round. Her plan is to finish high school and one day become a doctor. What a marvelous, fabulous goal. What can we do to help her thrive? And of course, she wants to bring it back home. She wants to be able to help people with disabilities, children in her own community. So our goals for capacity, or I'm sorry, goals for Claire. Claire has full capacity. Even at 10 years old, we recognize that she's going to be able to make decisions for herself. She receives SSI and Medicaid. Her parents have a home, a savings, life insurance, and retirement plans, but no estate plan. Their goals are to help her maintain her independence and help her maintain her benefits. Fast forward years later, if the parents have no wills, their estate must go through probate. If there's no special needs plan, then the assets would be distributed directly to her. If Claire ends up developing additional health issues and they leave $1 million to Claire, she would lose her needs-based benefit or benefits. It's unfortunate but not surprising. And this is probably the most common of the situations we see. And of course, whenever we encounter it, it is very heartbreaking. But let's take a look at another family and a different set of scenarios or different fact pattern here. So let's meet the Wongs and their son Joshua. Joshua was born with Down syndrome, and he has some developmental and cognitive challenges with some vision limitations. He has a younger brother, James. I was talking about this over the weekend, and I think the term is a glass child or ghost child when you've got a brother that's or a sibling that's not disabled. But Joshua, who he absolutely adores, he loves school, loves swimming, loves playing with his friends, drawing, and working in the garden with his mom. Joshua's parents, Lee and Rose Wong, own a home. John works full time, and thankfully, his employer provides medical insurance for the entire family. Rose works as a bookkeeper part-time in her father's business, which is a blessing and affords them a lot of flexibility so that she can take care of the boys both before and after with extracurricular activities. Although Joshua plans to get a job after high school, he will need care for his entire life. While he receives Social Security, income, and Medicaid benefits, while his parents are alive, they provide the love, care, and resources he needs to live a happy and fulfilling life. His parents have a home, savings, life insurance, and 2 retirement accounts. They have simple wills that they set up shortly after they bought their home, but before the kids were born. Their simple wills leave the asset estates first to each other and then to the 2 boys. Unfortunately, the wills do not include any guardian nominations for the care of their minor children or address any specific planning needs for Joshua's care. And I see this scenario all the time. In fact, I've seen it in my own family where you pull up a will that's 30 years old and the people that are either nominated as guardians or nominated as executors may not even be alive anymore, or the person who's either deceased or on his or her deathbed, may not have had contact with the person they've nominated for decades. So that's a big burden to leave for somebody. A lot of challenges navigating the system and all the requirements that Joshua is going to need for his future. Some goals and concerns for Joshua include the following. One is to provide the same type of care and nurturing environment that will look after his medical, social, and daily needs. They want to maintain his government benefits, and they also hope his younger brother will take over his care someday after they are gone. Fast forward years later, when Joshua was 18 and James was 14, the parents, Lee and Rose, passed away unexpectedly in a car accident. Because their parents had not nominated guardians for the kids, The court had no guidance and determined that John's parents, the children's older grandparents, would be the best choice. You'd think that was a good decision for the boys, but the downside was that the grandparents lived out of state. Again, something we see very frequently here in California, because although we're encountering some challenges recently, for decades and decades, California was the leading destination for people to relocate from around the country. But what this means with grandparents who are out of state is that the boys are going to have to be uprooted from their family home, their daily lives and routines, and their teachers and friends. It also means starting over with schools, doctors, and therapy. It was a difficult time not only for the boys, but for their grandparents as well. The grandparents were already living on a conservative retirement income. They were going to need help financially to care for and raise the boys. Fast forward, parents with their wills require that their estate goes through the probate process. If you're not familiar with probate, probate is a lawsuit you essentially file against yourself to process your assets so that it may be transferred to the next generation. If there's not a special needs plan in place or the issue is not addressed, the court is going to be reluctant to do anything about it. They're just going to want to distribute the assets. Once the dust is settled, and by the way, in California, your average probate proceeding takes about a minimum of a year. Certainly here in Los Angeles County, it does. But once the dust is settled, Joshua and James inherited just over $1 million of assets. Even though they split the inheritance, it is still too much money for Joshua to maintain his government benefits. Like Claire, our last family, Claire Jackson, it will take years to spend down before Joshua will be in a position to reapply. And so not only does this inheritance kick him out of the much needed benefits, it will also not be enough money to last for the lifetime of care that they anticipate he's going to need. Years later, when Joshua's grandparents passed away, he had to go back through the court system again to name a new guardian, or depending on which state you're in, if you're in California, once you turn 18, a new conservator for him. They're essentially the same role. At age 45, with his health starting to decline, the court wanted to place him with his younger brother, which was what his parents' wishes were to begin with. However, by that time, James lived abroad with a new wife and kids in a small flat and was unable to provide the care he truly needed. James had to be placed in the best faculty he could find close to his doctor's school, or James had Joshua to place him in the best facility close to his doctors and friends. As we reflect back, we know this is not what his parents wanted or anticipated, nor did his grandparents. It's a very sad situation indeed, and I'll show you in a few minutes how some simple changes could have created an ideal situation for Joshua. So that's our second story, the Wongs. Let's go on to our third family, the Petersons. And this is another situation that people don't think about, but Leanne and I both have encountered almost this identical fact pattern. So who are the Petersons? Meet the Petersons. This is Matt and Ellen and their son, Michael. When Michael was 18 years old, he had an unfortunate car accident, which he suffered a traumatic brain injury and some other physical limitations. As a result of his accident, he now has cognitive impairment and difficulty focusing on any one thing for too long, which can create some very frustrating moments. The situation that I'm thinking about, we had a young man who got hit by a car in a crosswalk just a few years beyond this. Anyway, for Michael, his right arm and his leg have permanent nerve damage, so it is difficult for him to walk or stand for long periods of time. He has fought with depression and has had a hard time keeping jobs. And of course, with pain like this, you're also at risk for exposure to opiates and potential opiate addiction, which is a whole nother realm of challenges for these families and for poor Michael. He currently lives at home with his parents and has a great job at a nursery where he enjoys watering and arranging the plants for a few hours a week. Luckily, his employer is very understanding of his condition, and they've worked hard to keep his stress levels down by having him manage just a few things at a time. Not all of us are so lucky, but they've found a good situation. Although he works a few hours a week and goes to school part-time, he will need some level of medical and financial care for the rest of his life. He is receiving Social Security income and Medicaid. His parents have a home, savings, life insurance, and 2 retirement accounts. Like the other families, they also have a set of wills in place. If I haven't mentioned this before, a will is a set of instructions to the probate court to be used when you're deceased. Therefore, any assets governed by a will are by default going to go through probate in California. Probate court, the reason you want to avoid it if you can is simply time and money. A probate proceeding, as I mentioned before, takes a minimum of about a year in Los Angeles County, and it costs between 4 to 8% of the gross value of the estate. So $1 million estate that we've mentioned before would cost you about $50,000 in probate fees. All money that could have gone to Michael instead goes to probate fees and costs. Now, his parents are mostly concerned about when they could pass away. They want to set up a plan that will provide financial stability and any ongoing care and support he will need after they are gone. A few years after the accident, he receives a settlement from the car accident, and his parents put the money into a savings account for him to use later as an emergency fund. Unfortunately, one of the things they don't realize is that this ends up disqualifying him from Medi-Cal benefits. So again, flash forward in our story. Fortunately, he was able to requalify for his Social Security income and Medicaid after years of spending down the settlement he received from the car accident. Unfortunately, due to his injuries, he continues to struggle. He still has a difficult time keeping a steady job, so those benefits were very important to him. He has struggled with depression and seizures. He's also had a hard time managing money, and he spends money frivolously with day-to-day details like remembering to pay his bills. A few years later, after his parents passed away, first his dad and then his mom, each had wills which they thought were sufficient for their simple no frills estate. I hear that a lot. Oh, my plan's very simple. It's very easy. However, their modest estate has still had to go through the public probate court to retitle assets and pay off debts. This was an unexpected delay. A year later, after the probate case has finally made its way through the court system, and the assets get delivered to Michael outright in one lump sum, between their home, retirement plans, and life insurance, they left him about $1 million. Like Claire and Joshua, this outright distribution disqualified him from any needs-based government benefits. One of the downsides of going through the probate that Michael found out was hard was the details of his parents' assets and about Michael being the beneficiary. All these things were open to the public. And wouldn't you know it, a savvy con artist buddied up with Michael and talked him into pitching into investment deals that were too good to pass up. Sometimes, in my experience, the money doesn't even get to Michael because one of the things that you may not be aware of is there are a whole host of companies that go down to LA County court system every single day of the week, business day, and they record all the information that is in the new probate filings and immediately start soliciting anybody who's a beneficiary. So one of the very common offers that somebody like Michael will receive is an inheritance advance. And the pitch is basically, hey, don't wait a year to get your money. We can give you a check within a couple of days. Just come on down and come see us. Well, what they don't really make clear or explain is the rates are just absolutely astronomical. I mean, you're looking at probably losing about half of your inheritance or whatever portion you receive in advance. It's one of the worst deals going, but this is all what's allowed, and this is part of the business of working through the court system. So this is definitely not the outcome that Matt and Ellen envisioned when they set up wills with their simple, modest estate for Michael. We share these common stories to scare you a little bit, but also to highlight how easy it is to unknowingly make a couple little mistakes along the way and really create a disaster. I promise we're not going to leave these families in these terrible situations. Leanne and I will show you a better way to do this as we go through the seminar. But let's shift gears a little bit. And actually, I'll turn it over to Leanne to talk a little bit about government benefits and how the system works. Take it away, Leanne.
Yeah, thank you. Okay, so this is going to be a fairly high level description. And I got to tell you, it's really exciting times right now because the benefits are changing a lot. So some of what we're talking about here has a lot more nuances based on some fairly recent changes. One of the big dates was September 30th of this year for SSI through Social Security. But anyway, lots of exciting stuff happening. So I think that the fundamental concepts, though, is you've got to realize two things. The benefits fall into two buckets. One is a means-tested bucket, meaning that it's a fancy way of saying that somebody is poor and they don't have resources, or they have very limited resources. And if they meet the threshold of those resources, they get certain things. And that contrasts with other programs. So I hear a lot of times somebody will say to me, I have Social Security. Well, that doesn't tell me a lot, because that could be a number of things. It could be on the means tested side, where it is SSI, supplemental security income, which is means tested, in which case I have to be really sure not to violate the rules. Or it could be on the earned side of things, meaning that we have earned that Social Security. So what do I mean by that? There's a couple things. It could be that somebody has qualified for Social Security disability insurance. So, for example, when you're working, if you look at if you're a W-2 employee and you look at your pay stub, it will show a contribution made into this program. And the point of that is that if you were to become disabled, and you could evidence that you had a disability, then you can make a claim on that. And Social Security will pay you Social Security disability. That is not means tested, you guys. You have paid into that program. You've earned it, so to speak. And so that becomes a very important distinction, because you can't lose it. Well, unless you became not disabled anymore, but you can't do something that would cause you to lose that. And along the same lines, Medicare couples with that Social Security disability. And Medicare, just like if you're over 65, one qualifies for Medicare. If you're under 65 but fall into that disabled bucket, you also can qualify for Medicare. And that is a wonderful insurance. So when I hear that, I'm like, yes, we've got good insurance for the person. On the means tested side, we have the SSI program, we have Medi-Cal or Medicaid. We may have in-home support services that links with Medi-Cal. In-home support services is an amazing program where you have a caregiver that's being paid to help take care of the individual. You have to qualify for it. They have a very reasonably complex model that they use to evaluate how many hours of care you get. It's something that we're always advocating and pushing for, to get more IHSS hours. You may have Section 8 housing, which is a subsidized housing allowance. It comes different ways. A lot of changes in Section 8 housing this year also. And then there also could be temporary aid to needy families. So I think the biggest ones I see are SSI, Medi-Cal, IHSS, and then sometimes Section 8 housing. The rules for SSI have changed a little bit, and thankfully, we no longer have food. If somebody contributes to your food bill, it used to be you had to report that to Social Security, and you had a deduction against the money that you got. So it was really a bummer. As of September 30th, that has gone away. There's also been some changes in housing contributions. That's a little bit more complicated, but it is possible to have an outside source contribute to housing, provided that the individual contributes some themselves. You may not have a loss there. So really positive changes. I think the important thing to realize is that these benefits are the safety net for an individual, and they are at the poverty line. So deducting things like housing or food contributions, it just stinks. I'll be blunt, it just stinks. Who could live in Southern California on SSI, which maxes out at a little under $1,200 a month, and pay for a place to live? It's just not possible. So there you go. So means tested, not means tested. Whenever you're talking to somebody, that's probably going to be the first thing they're asking you, because we have to be so careful that we don't cause any loss of the means tested programs.
Oh, yeah.
Other programs that are really important. There's I'm old school. Sometimes I call it the Disabled Adult Child Benefits, the DAC program. It's actually got a new name called Childhood Disability Benefits. Listen up. This is the most overlooked benefit by people. I'm going to say it one more time. The most overlooked benefit. If an individual has been diagnosed with a disability under the age of 22, they will qualify for one of two things. When the parent retires, that child can now qualify for 50% of the parent's Social Security, and that is no penalty to the parent at all. So for a child that maybe has been receiving SSI, an adult child has been receiving SSI, now they can grow to the CDB benefit, and it's no longer means tested and is more than the SSI money. So I cannot tell you how many times I see a parent who's retired that has not gone in with their child to qualify for that bump and that change in the type of benefits. The second part is if the parent passes, then the child can receive up to 75% of that parent's Social Security. So that's another one that's missed, because they get bumped from, say they've had the 50%, but they forget when the parent passes, they can go in and increase that eligibility. So hope that I can drive that part home. The other way that we get SSDI is a child with disabilities that actually has had some work credit. You don't see this very often, but I have a great story of one that we did. It was a young man who at age 17, sadly, became extremely ill, and with a very, very high fever, and it caused brain damage. It happened prior to the age of 22, so it was considered acquired as a child. It falls in that category. But the interesting thing about John is that John, you guys remember Blockbuster with all the videos? John's job, he absolutely loved working there because he loved movies and videos. His job was to sort the videos. And you can imagine, every weekend, every Monday morning, all the pile of videos would come in. And so he worked a lot of hours every week for many, many years at this job, despite the fact that he was clearly an individual with disabilities. I mean, he was nonverbal, had some physical impairment and so on, but he did that job so well. He actually qualified not for SSI when that job went away, but he qualified for SSDI, which was amazing because then he got Medicare, then he didn't have to deal with the means tested aspect of the benefit. So it does happen. You have to have worked the right number of quarters, and it's pretty significant. But in John's case, he had worked at Blockbuster, for I think 10 years, and he did qualify. So the other part is Medicare, and I've kind of alluded to it. I'm not the type of guy that's going to bash Medi-Cal resources, because I frequently find that some of the Medi-Cal resources are the best of the best. For example, UCLA, if you're out of UCLA with all the teaching programs and so on, you may be able to get the best neurologists there in their neurology clinic, or the best mental health, all paid for through Medi-Cal. So I like to encourage people, particularly that are in these larger centers of population, to not always poo-poo Medi-Cal. It really depends on the type of service and the type of diagnosis. But having said that, Medicare can be just the golden ticket. Medicare insurance is very good. And once you have Medicare, you can qualify for Medicare supplements, either through a Medicare Advantage plan or through a PPO. So they're really, really good. It does take 24 months after the qualifying event of the disability. But assuming that somebody's going to be disabled for life, I mean, yeah, it's 2 years. Yeah, it's annoying. You've got Medi-Cal in the meantime, but definitely want to apply for Medicare. So it's good stuff. Means tested programs to summarize, SSI, any kind of Medi-Cal / Medicaid, but we have changes in the rules. So as of January 1st, 2024, there's no longer an asset limit test. And so that's actually allowing people to have money. But now I'm getting the phone calls saying, well, I'm going to qualify for Medi-Cal no matter what, even if I get the $1 million. Hold on before you say that. Careful, slow your horses, because you're going to be generating income from that $1 million. And that income may exceed the threshold of the Medi-Cal income limits. So it's super important to really check this out when you're planning with an attorney like Scott. Make certain you don't presume, therefore, I don't need any help. So I hear people saying things like, I don't need a special needs trust. And maybe that's true. Because all I get is Medi-Cal and I'm not worried about the asset limit, but income counts too. So be careful. If you have Medicaid, Medi-Cal, then you get the in-home support services. And sometimes that is the number one benefit I want. I may not care as much about the Medi-Cal, particularly if I have Medicare for the individual, but having that in-home support services with the extra caregiver support, because that is so expensive. And the only way to get IHSS is to be linked to Medi-Cal. So super important. Section 8 has a means testing component in terms of how much rent they charge you, and then TANF the same thing. So these are the important programs for means tested.
Really great summary, Leanne. Thank you. So the next topic that relates and arises out of this is the issue of guardianships. Again, in California, depending on your circumstances, we may be looking at the issue of a conservatorship. They are essentially the same proceeding, but with the big difference being that guardianships are for minors and conservatorships are for adults. But at the end of the day, what they are is a lawsuit, and they are a request to put somebody's life, some or all of it, under the supervision of the guardian or the conservator to be in charge of that person. And sometimes it's needed. So we start from a 10,000-foot view with basically there are two big categories. The guardian of the assets or the guardian of the estate. They're the people that hold legal title to assets. The other category is the guardian of the person. That's the person who would make medical decisions on behalf of the disabled person. And when you have somebody that suffers from developmental disability, what you may be doing is looking at what's called a limited conservatorship, where the presumptions are flipped, with the goal of the court system trying to preserve as many of the wards, rights, and privileges as possible, all done in conjunction with the regional centers. So, what to consider? You have to start with the basic premise that this is a lawsuit. If you can avoid lawsuits, you're generally better off to do it, especially if you can avoid lawsuits where the court is supervising the control and management of funds, because what that means is that who's ever in charge of them is going to be bonded, that there's going to have to be regular accountings that have to be court approved and supervised. You have a lack of flexibility. It's difficult to do anything quickly or without getting prior court permission if it is a major option. All right. Next, we get into other planning options. And these options include what I sometimes affectionately refer to as backyard estate planning. You've probably heard the term shade tree mechanic or self-help. One of the things that's not unusual in this area is that people engage in trying to do all of this themselves. They don't want to get professionals involved. And oftentimes we find that they create more problems than they solve with their efforts. So let's go through some of the popular ones. The first solution is I will often get parents that'll come in and say, well, I'm just going to disinherit the disabled child. Usually not really what their true desires are, but they recognize the loss of the benefits would be devastating. So is there a way we can preserve the benefits, manage the care, and not punish the child? The next one, which is almost as scary, sometimes scarier, is to give the inheritance to for that sibling to others. We often call this the hope and the prayer plan, because if you give the inheritance to, let's say, a sibling, then those funds get subject not only to that sibling's creditors, including a spouse. They could get caught up in a divorce proceeding, but also what plan does this well child have? And if we lose the well child a few years later, their assets could end up going to somebody else or grandchildren. You get the idea. The next idea is to do a spend down, which is great, but again, it doesn't seek on preserving, maximizing, and investing the assets. You're really looking just to get rid of the money, and it really sort of defeats all the rest of the purpose. Another option is life insurance on the caregiver, so that when we lose the caregiver, you can create a fund for the beneficiary, but generally without an ABLE account or a special needs trust, you don't have a good solution there. And then our next two are our absolute favorites. So Leanne's already hinted one is the ABLE account, and the next is the special needs trust. So let's take a closer look at these. So disadvantages, or the advantage first of disinheriting, of course, is you maintain the government benefits. The disadvantage is there's no money for the disabled child, which seems to defeat the whole purpose. How about giving inheritance to others? Well, I've already given you a preview of this stuff. You don't lose government assistance, but again, it could be subject to all these things. And I can't tell you how many estates that I personally have had to unwind and try going into court and arguing that the true estate plan is exactly opposite of what was written, that there was a moral obligation. Those things just don't get enforced. Spend down, of course, the limits. That's to pay off or pay down debts, purchase goods and services not covered by Medicaid. You can allow the beneficiary allows the beneficiary to keep government benefits, but again, that's a really narrow margin that doesn't give a lot to work with. There's no long-term access to funds. There's no additional funds available if there's an emergency or other potential things. So not recommended. Another way to do this is you could have the beneficiary disclaim the money or give it away once they inherited. This is another technique that people will use sometimes, but this often has the worst of all worlds, and that is that it results in the beneficiary being disqualified, and then also not having the money because they've disclaimed it or given it away. So that brings us to ABLE accounts. I love ABLE accounts. ABLE accounts, if you're not familiar with them, stand for Achieving a Better Life Experience. What a lovely acronym. It's a savings program for certain disabled individuals that does not affect SSI or Medicaid. The beneficiary is the account owner. There are low contribution benefits, and the balances at death end up getting paid to the Medicaid agency. A disqualified disability expense, so you can use the money and that is in this account to pay for such things as education, housing, transportation, employment and training, wellness and prevention, financial management and legal fees, and even burial and funeral expenses. Some of the benefits include that the earnings on these accounts are tax-free. Gifts within the ABLE account limits are gifted tax-free. The beneficiary benefits because they're able to have some level of control. It's a really lovely thing to be able to empower your child to be able to do this, or your loved one. They can save and manage their own account. It gives them a sense of self-worth, have access to the funds. Okay. Then we get to really the king of all this, and that's our special needs trusts. So again, we're gonna go through sort of a high level review of this. What is a special needs trust if you're not familiar with it? Instead of leaving assets directly to a disabled adult child, you can create a special needs trust either in your living trust or even a will. The easiest way to understand it is to think about it like a box or a treasure chest that holds all of your child's future assets, current and future assets for the child. So let me start with what is a trust? Well, a trust is really easy way to think about it, besides being a treasure chest, is that it's nothing other than a contract. It is a private contract that has three parties to it. The three parties are the trustor. Those are the people that set it up. If you're creating one for your child, you would be the trustor. Next would be the trustee. That would be the person who would be in charge of it. So they make the decisions about what to spend, how to invest the money, do all those types of things. As Leanne mentioned earlier in the presentation, she is a private professional fiduciary or a private trustee. So she does this for a whole portfolio of families. And then finally, the third party or parties are the beneficiaries. Those are the people that would be entitled to receive the benefit. So this, of course, would be our disabled loved one or our child. How does this work? An inheritance is properly overseen by our trustee. The beneficiary receives financial support. The assets are not given directly to the beneficiary in most cases. They're used but not owned by the beneficiary. They're used for wants but not for needs, paid out over time as the beneficiary gets older. So you put somebody in charge as the trustee who has the wisdom, who has the experience, who has the long history to be able to say, let's preserve some money here, or this would be a good use of maybe additional therapies or medical treatments, or whatever would help the loved one or the child thrive. Think of our trustee as a substitute you. What are our benefits? Well, first of all, it protects the assets. So some of the options we were looking at was just giving the money away or disinheriting the child. But what you can do with a special needs trust is preserve the share of the money that you want to give for the child. This allows the maintenance of the government benefits. It protects against the financial abuse because the child does not have direct access to the money. You have to go through the trustee. It has to be for a proper cause. It provides additional funds for the beneficiary's benefits and allows others to contribute. These are all fairly incredible benefits. Depending on how it is set up, it can also avoid the Medicaid payback. Assets are not exposed to creditors. It can provide continuity of management, minimize mismanagement, last the lifetime of the beneficiary, and a lifetime of advocacy assurance. Simply stated, you have somebody engaged to help protect your child or your loved one. So, types of third-party trusts, again, we're not going to be able to go into all the details, but here's sort of a high level. There are either first-party special needs trusts or third-party special needs trusts or pooled special needs trusts. Within the third-party special needs trust, there are several different flavors. We'll cover them briefly. So the first-party special needs trusts are the beneficiary has his or her own assets. These things are subject to stringent guidelines. One of the exciting developments that has happened in the last couple of years is it used to be that you could only set up first party special needs trusts through the court system. You had to go into court and actually ask the court to create these for the benefit of the disabled person. But the court has now recognized that there are plenty of people with disabilities, such as Claire Jackson in our earlier hypothetical, who have capacity. They just have these challenges. And so she can actually do a self-settled trust. The big issue with these is that they have to contain the Medicaid payback. So any benefits at the end or any funds remaining in the trust have to be used to deal with a Medicaid payback. So finally, the beneficiary needs to be under age 65 when the trust is created. That's another requirement of your first party trust. Your far more common trusts are your third party trusts. These are somebody that are funded by assets other than the beneficiary. The trustee has broad discretion, and there are several types. Quickly is a revocable third-party trust. There's no Medicaid payback provision. They're created using third-party trust. So this would be a parent or a grandparent creating a special trust that they're going to use to hold the assets for the benefit of the disabled child. So you can make these either revocable or irrevocable. With irrevocable versions, there are still no Medicaid payback provisions. They're created with third-party trusts, and they are basically done as completed gifts. The most common example we would see with these would be a family with a child. It sets up a fund that will become a special needs trust. The parents die. The trust then becomes irrevocable and at that point cannot be changed, but the trust is there for the benefit, again, with no Medicaid payback. All right, there's a couple other technical varieties. One is the 76-270 trust. This is also an irrevocable with no Medicaid payback. It is designed to receive distributions from a charitable remainder uni trust if you are engaged in any type of advanced planning. And then the C2B4 trust. This is also an irrevocable trust. Special needs beneficiaries must be under age 65. And it is used when the donor wants to avoid a Medicaid transfer penalty because they might apply for Medicaid in the foreseeable future. Once the assets are gifted to the trust, the beneficiary no longer has any rights. But again, they are used for the beneficiary's benefit. Finally, we would be remiss if we didn't mention pooled trusts. Pooled trusts can be a wonderful alternative. Pooled trusts are run by nonprofit organizations for investment purposes. They can be either first party or third party. The beneficiary does not meet the age requirements for the first party trust. And in situations where there is no family member or somebody that you trust to serve as the trustee. They are also good when the assets are smaller. Typically, if you have just a couple $100,000, they can make the costs of administering special needs benefits much easier. Okay, that was a lot of territory quickly. Let's talk about choosing a trustee. And for that, I'll turn it back to you, Leanne.
Okay, thank you very much. So it is really, really important to select a trustee. And a trustee, their role is a certain level of advocacy, definitely accountability. They have to show where the money's being spent, and financial oversight management. They have to make sure that the assets are productive, that they're earning, that they're growing, they're earning, or and so on. And they have to be looking at the spend down because we know that these funds are intended for a person with disabilities, and we have to figure out what's the longevity of the funds and how long they're going to last. So, what a trustee should not do. There's lots. So let me back up. There are lots of rules for trustees. This job is not for the faint of heart, sadly, and it can be very easy to run afoul of the rules of public benefits and just the rules in general. So a trustee should not distribute trust assets directly to the beneficiary. I cannot tell you how often I see this. It's at least once a quarter. I get a phone call from somebody who's acting as a trustee, and they've been giving cash to the beneficiary because the beneficiary asked for it. And that just creates this myriad of problems, and people lose their Social Security over it. Or their Medi-Cal too. So a trustee should not distribute funds directly. There's so many other tools we can use to still get finances to the beneficiary. Cannot commingle trust assets. It has to stay specifically in that trust for that individual. This last one has actually changed. It used to be very careful about making distributions for food, clothing, or shelter. Now that's no longer quite the case. Definitely food is okay. Definitely clothing's been okay for a little bit. Shelter's a little bit more complicated. I always, oh my gosh, this is my pet peeve. I cannot tell you, another phone call I get once a quarter is I can't pay for shelter. They just have to live in their horrible rat infested place. And that's not true, you guys. You can pay for shelter. The question is whether or not there'll be a penalty against the Social Security income for doing that. So that needs to be looked at very carefully. Tons of little tricks that you can use to make that happen. But the trustee should not automatically do it without significant analysis. Things that the trustee can do. This is the happy side. And notice there's got more things on the right than the left. Purchase a home. You can literally purchase a home. You can pay for household expenses, furnishings, the cleaning person, the household supplies, whatever it is, any kind of educational things, any legal fees or accounting fees. A vehicle. I see that one all the time where a trust is paying for a vehicle. Vacation travel. If the beneficiary is able to travel and there's sufficient funds, I think that one should be highly encouraged. And how you set that up, they may need a caregiver to accompany. There's all sorts of nuances there, but it should not be ruled out. You should definitely be encouraging, provided there's adequate finances. Cell phone, internet services, those are not considered utilities. So those can definitely be paid for by the trust. Cleaning services. I find that, the cleaning services sometimes gets overlooked, but the reality is for most of the individuals I work with, most of the beneficiaries, they're not necessarily able to do that. And that becomes a burden. So I hope that a good trustee is always asking that question, can we provide a cleaning service? And if so, though, make sure you're doing it legally, that there's proper workers' comp in place, and don't just hire somebody under the table because if they slip and fall, your trust may be at risk. Any kind of care, any kind of medical procedure, or any kind of caregiver that's not covered by public benefits. So the rule is try to use the public benefits first. So, for example, if I had in-home support services, I use that before I hire a caregiver. But care is definitely a huge expense for many of the individuals I work with. Okay, so more things you can do than not do. Everybody's needs are different. You've got to have a flexible plan, and you have to adjust it to the beneficiary's needs. And to bring that back to what is a trustee doing, a trustee needs to meet with that beneficiary and their advocates and understand what is it, how much money do we have, where is it best used, how can we fit the person's needs. It's not a cookie cutter plan. Must last for their lifetime. That's a bit harsh because the reality is sometimes there's just no way to make it last for the lifetime. But you got to have I think you want to document well and make sure that you've considered, is this important? So if somebody comes to me and wants the brand new car, but they only have $400,000 and they're 60 years old, I'm probably going to say no, quite frankly, because a car is probably not the number one and most important thing that money should be used for. Create lifelong advocacy, yeah, for sure. And that's a good example of being an advocate, is saying no sometimes is advocacy. Next slide, Scott.
Just like saying no to our kids, right?
Exactly. Areas to consider. I always look at this first one. Can they manage finances without greater assistance? So, for example, I might decide that I want to add money from the trust into an ABLE account. That's allowed to do. But if that individual is not able to manage that money, how I do that, I'm going to decide on the granularity and what the intent of that money is, and so on. Will it just qualify from public benefits? Would an inheritance? And that's going to go into that equation of what kind of a trust vehicle do I use? Will they have access to lifelong financial resources like public benefits? Or is that something that's not going to be there? Oh my gosh, you've got the hot button here. Is somebody at risk of being unduly influenced by others? I mean, we're all unduly influenced by others. Come on, it happens to be every day. Um, but the question is to what extent? And so I find that a lot of individuals with disabilities, there's a tendency to be lonesome. There's a tendency to crave, companionship and so on. And that puts them in a very highly vulnerable category. A good trustee is going to try to suss that out. But the reality is you cannot completely prevent it from happening. Just like the parent can't completely prevent it from happening. Um, if you're gone, meaning the parents, will the caregiver be able to make decisions on their behalf? Um, it depends. You got to look at the ability of that decision making power. Other considerations: taxes. The income may be taxed. Whether the trust is revocable, can it be changed or fully dissolved? When is it created? I see that one happening a lot. Probably the vast majorities are created upon the parents passing, but don't always make it that way. Maybe you have grandparents or their family members that want to contribute to this special needs trust, in which case you may want it to be a standalone and the timing is today. Um, Coordination with the estate plan, yeah, they have to go hand in hand for sure. It's not an isolated event.
So, Leanne, let's have you talk about your favorite, the power duo.
Yeah. Yeah. So I get asked this question a lot. Now that there's able accounts, why do I need a special needs trust? And so able accounts have limitations. So some of the limitations are the amount of money that you can have in there. It tops out at around $100,000 unless the beneficiary is contributing work earnings there. So I won't get into the technicalities, but it has a limited amount. So if I've got $1 million estate, I can't put it in able. Um, One of the biggest things that isn't really talked about much, but I really consider, is that able account is owned by the beneficiary. It is their money. And that's a beautiful thing in many ways. It means they have control over it. It means it doesn't count against any kind of public benefit measurement. But it's also a double-edged sword because they have control of that money. And so if you're dumping a bunch of money in there and you're hoping that it's going to be for savings, but they have impulse control problems, probably not a good way to go. And there are other tools that you can use. So just, yeah, and it does cover things that the special needs trust maybe can't do, like give cash. It's a great way for them to go get cash. But just realize that once that money's there, trustee has no control over it. Doesn't No right to ask for receipts, no right to ask where it got spent. It's gone. Special needs trusts definitely can be a primary source of funds, for large amounts, certainly for inheritances. In general, we try to cover supplemental things that public benefits don't cover. But I think rather than saying I think sometimes people think it's this often like black and white off on switch, toggle switch. I don't look at it that way. And again, I'll take housing as the biggest problem we have in our geography. Yeah, they're technically the Social Security is for house, shelter, and food, but give me a break. It doesn't cover anything. So that's absolutely my number one first thing I look at is, should the trust be augmenting the housing situation? So don't necessarily discount that. But in general, you always want to look for public resources to be the primary care source, and then the supplemental aspect of the trust. So use those IHSS hours before you hire a caregiver, kind of thing. All the things that it doesn't cover. Yep, you can read those lists. Insurance is a great way to fund a trust. So sometimes the parents will use their life insurance to fund it. There may also be medical insurance. A number of years ago, the rules changed where you had a child with disabilities. They were still covered after the age of 26, which is a wonderful thing for insurance. Don't overlook it. Oh yeah, this is a good one. The timeline. So I'll let you guys read this, but this is really important, I think, to look at. It's a great chart. It's kind of map your way. It's a great maps, figure out where you are with your child and explore these things. At age 18, a lot of things happen. So like, don't automatically assume that the Medi-Cal will stay in place. You've got to do something. So at age 18, really look at actually 17 and a half, look at what's going to happen at age 18. So if your child did not qualify for SSI, at age 18, they're going to be their own household. They're going to qualify. So get in there, start talking to them about getting those applications done. Medi-Cal is, even if you've got the Medicaid waiver or you're receiving Medi-Cal, don't assume that it will stay in place at age 18. You've got to be more proactive about it. And the rest of the chart I'll let you read.
All right, Leanne, I was the guy that sort of rained on everybody's parade and told everybody about the bad things happening to our three families, the Jacksons, the Wongs, and the Petersons. How about we let you share some of the good news with some of the tools that we could use? So,
Yeah. So the good news are, yeah, go ahead. The Jacksons, go for it.
right.
Yeah.
So here's where we started. And with a do over,
Yeah. So the biggest thing is that that special needs trust was created. There was also an ABLE account created, and so now there's a place to put money and give her some independence while still keeping her government benefits. It's a really good deal. So super important to have that special needs trust created.
and you would do this in conjunction, of course, with the ABLE account as well, right?
Typically, you have to qualify for it. So there's some rules. Those rules will probably be changing right now. You have to have been acquired your disability prior to the age of 26. It's been talked about that they'll increase that to the age of 48, but it hasn't actually happened. So we have to look at, do we have a qualifying diagnosis and so on? But it's certainly on my checklist of what I look at.
Okay. Forgive me, I have their name wrong here on the slide. These things happen. These are the Wongs we talked about earlier with Joshua. So you remember Joshua had a developmental disability, and previously we had no guardianship, able account, or special needs trust. And with our do-over, we've been able to protect everything.
Yeah, so this is awesome. And then I noticed he's got an ABLE account, and in this case, because he has a guardianship, the guardian is going to be the one that's managing that ABLE account. So the trustee, which may be the same person, maybe it's going to be Joshua's brother, is the trustee and also the guardian. In which case, he's going to manage the ABLE account. Maybe because the brother moved to a different country, might be a different trustee like myself. Maybe it isn't a family trustee, but they're still going to have that ability. Actually, the brother might still be the guardian for, as a family member, hire a care manager to make sure that he's looked on, and then have an independent trustee do this. But he's going to be so much safer with this model.
And one of the wonderful benefits of an arrangement like this is you can use the ABLE account as sort of a training ground to help
Hmm.
Joshua develop his money skills. So you
Yeah.
put money into the ABLE account, see how he does, and
Hmm.
discover large chunks disappear. You can have a conversation,
Hmm.
Joshua.
Yeah.
You
Yeah. And it's, what's really good about that too is that you're limited on there's by law, you're limited as to how much you can put in the ABLE account. So if you have an oopsie, sorry, you're done. I can't add anymore. It's a great consequence.
right, right. So that's great. Okay, and I'm sorry we got the Peterson's name wrong too. But this is Michael. Michael, you remember, was the young man that got into a car accident when he was 18. Also independent before we had not much. And with our do over, we again have a robust plan that incorporates all this stuff.
Yeah. And for him, it's going to be super important to have those benefits maintained. And I would be willing to bet, particularly given his physical disability, that he has in-home support services through Medi-Cal. And so however number of hours he gets that gets awarded is going to be a huge contribution to not having to spend more on care costs. So nice plan.
Very nice. Well, thank you. So, Leanne, if you had to guess, who do you think needs to do estate planning?
Oh, just everybody does. Yeah.
Everybody.
Yeah.
Whoops. Uh, oops. Let me throw that out there. Yes. So the do-over results. So everybody needs to do estate planning. I will tell clients at other seminars that if you are single, childless, and broke and don't love anybody, then you can probably skip it. Uh,
Yeah.
but hopefully you're not in that category. But everybody, but certainly somebody with a child with a disability, a recipient with a disability, a grandparent or loved one wants to gift to somebody with a disability. All of
Hmm.
these are people that should be thinking about. A couple of common
Hmm.
misconceptions as we come to the end here. Special needs planning is poverty planning. It is absolutely not. And in fact, one of the things that we all take very great pride in is preserving, growing, and protecting legacies and really increasing the quality of life for our loved ones, just like their parents and their grandparents do on a daily basis. We love these people and want to protect them. Trusts are costly and only for the wealthy. That's not true. Not many families do this type of planning. That's also not true. Siblings and other families will care for my loved one. That's a difficult one. That's a lifelong commitment, and it depends on really your family, but it's a lot to ask. Uh, Next is my loved ones won't need benefits. If the benefits are there and they're designed and your child qualifies, why would you not want to get them? Next misconception is do-it-yourself plans are just as effective, and I hope we've shown you that they are clearly not. And also, it's too early to think about this. We're not ready to do this type of planning. And my attitude is it's never too early. And in fact, in almost every trust that I create a sort of emergency backdoor special needs provision because you just never know, even the healthiest of families, crazy things can happen. So that's what good planning is all about. So, hopefully you're not feeling too overwhelmed by all of this because it's a lot. We know and understand that most parents of a child with special needs are busy dealing with their day-to-day lives, between the doctors and the jobs and everything else. And what do you do and how you do this? We find that misconceptions and lack of knowledge is often the biggest impediment and the biggest challenge. That's one of the reasons why we spent some time here today, and are both Leanne and I are both very dedicated to educating the public about this. Um, Unfortunately, Leanne and I see this type of plan more than we care to share. Um, I know it's funny, but it's not. It's really tragic and heartbreaking. We hope you don't find yourself in this situation. The impact can be loss of benefits, added expenses, wrong people in control, caregiver burnout and stress, family tension, and confusion. These are all bad things. So, as Leanne mentioned earlier, no action can impact not only you, but also your loved one and other members of your family. So our attitude is we're going to help you sort of take a preview of what we do and how we put the infrastructure in place to be able to do this and to be able to help work with somebody like Leanne. And that is, we have for the planning side a simple 5-step system. It starts with, let's get to know you. Let's sit down. Let's learn about your Claire. Let's learn about your Michael. Let's learn about your Joshua. What's going on? What are your concerns? What support systems do you have in place? What benefits are you availing yourself of? What are the risks? Next, we go to designing and developing the plan. That's something we sit down and do a state of the art. And we have so many contingencies, and we've encountered so many different challenges from other things that we've done. We think through every potential landmine in your path to make sure you're protected. Um, Then we sit down and we review your plan choices and also review your assets and confirm your funding. Remember, what we're talking about really is assets to be used for the care of your loved one. So having a good understanding of what your assets are, that they're properly titled, that they're properly set up to be managed, no matter what the circumstances are, and in a way that will not jeopardize this precious resource of government benefits, is really what it's all about. After that, we sit down, we do a signing, funding, and plan delivery. So we deliver a whole plan. And then one of the things that we consider ourselves unique for is we stay in touch with our clients. So once you do a plan with us, you're part of the family. So we will reach out to you. You're always welcome back to our office. We typically have our clients back at least every 3 years just to review things, to make sure that everything's in place. And we never charge you for those review meetings unless you want to make changes to your plan. So it's a wonderful system. It's all designed to take care of the caregivers and the people that have done so much for their families. So we like to think of this as an owner's manual. We put together not just a paper here, paper there. Where is it? Is in the back of the closet. We're going to put together a whole organized binder that includes everything. Most likely, you're going to need some type of trust. If there's a special needs trust, whether it be in your trust or a standalone trust, whenever you do a trust, you have to do a will. It's called a pour over will. Property agreements, powers of attorney, healthcare documents, and we can even set up a funeral trust to make sure that your funeral's fully paid for and funded, so that you don't have to worry about this. Now, let's talk about fees. What does it take to get us involved? Well, as I hope we've tried to convey to you, this is a pretty complicated area, can be. There's a lot of trips, traps, and landmines. But we do this thing on a complete comprehensive package, and our fee for all of the planning including what we call an integrated special needs trust is $6,495. Once in a while, a client will say, well, I really want a standalone special needs trust. And that's a situation where perhaps you have a grandparent that's ready to start contributing now, and we will add on a special standalone needs trust for an additional $2,500. So our offer to you at Schomer Law Group is that for sitting through our presentation today, whoops, let me get back. I'm sorry, my slide's a little messed up, but we are opening our doors to you. So my hourly rate to do legal services is $750 an hour, but we believe in what we do. We believe in the importance of taking care of the families that are interested. And for that, we are willing to offer you a no cost, no obligation consultation. Come have a cup of coffee with me. Let's sit down. Let's talk about your situation, and let's figure out what you can, how we can be of assistance to you. Now, I have been taken advantage of in the past, so I do, since I'm sharing my valuable time, I do have a couple of rules, and that is if you're a dedicated do-it-yourselfer and you're going to do it in the backyard, please don't ask for one. If you've been to several workshops and you're procrastinating, when you're ready to go forward, we're here for you. Or if you've already done a plan and you're looking for a second opinion, you can certainly hire us to do that. But that's not what the free consultation is designed for. It's there to assist people who are looking for trying to put a good plan in place. So if you'd like to schedule a consultation, we have a QR code. I'll leave this up for a second. You don't have to do it by QR code. We are thoroughly old school. You are welcome to just pick up the phone and call us, or you can email us at info@schomerlaw.com. We'd be happy to respond and find a time and set something up. We do our initial consultations either in person or by Zoom, and once in a while we even do them by telephone. It's really what you're most comfortable with. Our personal preference is to see you in person because we just like to meet people. face to face. So what can you expect if you come to see us? Well, basically there are three parts to the meeting. First up is that it's an attorney-client confidential session. So, but the first order of business is I'm going to get to know you. Tell me about your loved one. Tell me about your special needs child or adult. Let's see if we can get an understanding of what's going on. The second portion of the meeting is once I have an idea of what your issues are, I will turn it over to you and answer any questions that you have. And then third part of the meeting is we'll sum up, and then I'll just ask you to make a decision. Yes, I'd like to work with you, Scott. No, I don't. And you can say no. But the point is, we hope you're ready to think about it and actually take action, as Leanne talked about earlier in the seminar. So put your knowledge into action. See if we can help you do something about this. We hope you found this useful, and hopefully you can use this as a springboard. So don't be afraid to scan and book an appointment today. And one other thing I want to let you know is Leanne and I are both available to give this seminar or presentation to other groups. If you have a friend, a family organization, and you'd like us to be a guest speaker, we would be honored to do so. Leanne, do you want to throw up your contact information if anybody wants to have a separate conversation or consultation about perhaps having you take over?
Sure.
Assessor or
Sure. You can reach me at hitchmanfiduciaries.com. It's HITCHMANFIDUCIARIES.com. There we go. It's on I thought it was on the slide.
There we go. Okay. All right. And so we've gone a little longer than we expected. I was just looking to see if you have any questions. You're welcome to put them in the chat. But I think we covered a lot of territory.